All right, the time is 6:35. We have a quorum of the Planning and Zoning Commission for the September 23rd, 2024 regular meeting. At this time, we'll open up our work session and answer questions that the commissioners have for staff. So item 4 is where I want to jump in today with consideration and action regarding the request of Monty Anderson, applicant, for an amendment of a plan development district on Wheatland Plaza Shopping Center, more commonly known as 402 East Wheatland Road. So the request is to amend the existing zoning, the future land use map designation as retail commercial. It is a PD and by ordinance number 2461. So that's going to be amended. This is an aerial of the subject site, and the existing zoning is B in blue. Downtown district is a slighter shade of blue to the west, with SF7 residential to the south and east, multifamily 21 to the further west, and to the north you have Reed and Hardin of Duncanville Independent School District and First Presbyterian Church of Duncanville neighboring to the north. So this zoning request consists of 5 changes to the aforementioned ordinance. Those are section 2.c, section 2.c2, section 2r, section 2cc, which will be a new section. Exhibit C will be an amendment to the existing Exhibit C, replacing with a amended new Exhibit C, which we have in greater detail explain all 5 of these items. So section 2C. And this amendment is to identify LOR, it's a local office retail district, as the base zoning district for the PD. In our zoning ordinance, in section 6.06 B2 B5, there's a requirement for plan development districts to select one conventional zoning district as a base zoning district. And the reason for that is to regulate all the uses of development that are not identified as being altered as part of the PD. At the time of adoption, the ordinance did not identify a conventional zoning district that was signed. So this omission has caused uses expected to be allowed by right to no longer be permitted under the new zoning regulations. So that is section 2C, cleaning up that omission and replacing it with LOR, which was the base land use that was previously permitted by right prior to becoming a PD. The second amendment is for the following 4 uses to be allowed by right under section 2C2. So in section 2, that's where all the uses are called out, and section C2 would be to allow for child care facility, daycare, community center, public, library, and then finally lodge or civic club. Now all these uses are permitted in the LOR district. However, lodge or civic club requires an SCP. So this is the only one that would be changing from an specific use permit to being allowed by right, lodge or civic club. Next is section 2R, and that's in quotes below. So what this section would do would exclude the residential development component from the regulations of 2R. And I'll read and go into a little bit of detail. But the RCS reads, previously, all buildings over 1,000 square feet in ground area shall have a flat roof and 3-foot parapet wall to screen rooftop equipment. All equipment must set back 5 feet minimum from the exterior roof boundary. So this, in bold, would add the word non-residential. So it would apply to the entire area except for the future residential component. So with this amendment, the request is to allow for perhaps not a flat roof. That's possible. but also for the screening to not have the 3-foot parapet wall. So that's the request in 2R. Then section 2CC is totally brand new, so at the very end of section 2. It is language that will clarify the allowed uses within the planned development district. And I'll just go ahead and read this verbatim, so we're aware of what's being asked. Even though in summation it's practically as simple as that one sentence. But all uses permitted under the existing use chart at the time of this ordinance was adopted shall remain permissible for the duration of the planned development district. Any future uses added to the base zoning shall be permitted in the same manner as outlined in the base zoning. Suites within Wheatland Plaza that have been previously occupied by a use permitted under this ordinance shall continue to be eligible for occupancy under that same use. New occupancy-related conditions or requirements shall not apply to suites previously occupied under the current use chart as the adoption of this ordinance. Some circular language there, but in general it's the gist that it's clarifying that uses under the base zoning are permitted. And then finally, Exhibit C, existing, and Exhibit C, proposed. So what the difference is, it has to do with that dashed line. In red, you have the 3-story max of 40 feet, and then in purple, you have the 2-story max of 30 feet. And so that kind of gives some clarity and some continuity being brought to a uniform 2-story max at 30 feet. So that's what's being proposed there in Exhibit C. And that really includes those 5 requests of 402 East Wheatland Road. And we will take questions and answer them as best as I can.
So my first question is about the I think it was lots that were originally required by SUP, but are being requested to be allowed by right. So I'm familiar with SUP. We voted on that, went through that a few times during my term as commissioner. I'm not as familiar with planned development. So if this is allowed by right under the planned development, is the duration, is it similar to the approvals we've done for SUP, or what does this shift?
So with this request, it would no longer have to be an SUP. So let's say a civic club wanted to operate within the boundary of the planned development district. It would no longer require them going through the SUP process. It would be allowed by right.
So with the SUPs, when we've done them, approved them before, there's been discussion about if there should be a 2-year period or extended forever, or there's been conversations about traffic patterns and community involvement. So if this is allowed in the planned development as a part of this amendment, those discussions wouldn't happen.
That's right. The particular use would be permitted by right, and it would not need to come before this body for special approval, or an SUP could be allowed by right.
So being that this was listed as a SUP rather than as the other ones are standard as a part of the water, and not, I guess my question was, what was the concern of larger civic club in the LOR that it was an SUP rather than allowed like the child care facility or community center?
So there are 3 uses that Lodge Civic Club is in, which is LOR, GOR, and commercial, and all 3 actually require an SUP. So there is no place that a lodge or civic club can be permitted by right, by current zoning ordinance, as they are allowed by right through a planned development district.
Thank you.
Sure.
Okay, I have a lot. Going back to the beginning when it was talking about the base versus the conventional. My question had to do with this plan development that we're talking about. How does that fit in with the base or conventional? And then is any of this, this change that's trying to happen, this isn't anything that has been done in and zoning department? This is something specifically that the income is asking for?
Yes, so all 5 requests are from the applicant. However, I will say that there was a instance where the owner of the property expected a use to be permitted based off the previous allowed LOR, going through the process, actually putting in their initial documentation to have a base zoning of LOR, the expectation that LOR would be base zoning, and then when the zoning or the ordinance was signed by the, and duly adopted by the city council, that was omitted. So this is a function of remedying that omission. So that's part of the reason that this is being amended. And then city staff said, okay, this is, since we're opening up the PD, if there are other things you would like to see, this is the time to do it. So that's we have those 5 requests.
So then at that point, my question would be, is this the type of precedent the city is wanting to start, in that change what we allow based on what someone purchased, when they got it? Because I remember where there was someone here before who bought something saying, well, I didn't know that I could do this or could not do a certain thing. And then after purchasing, they came because for us to change it. And so I'm just trying to understand, is this, this sort of precedence, is this what this is?
I'll say I don't hope that we have a precedent or a pattern of omitting things that should not be omitted. So a base zoning district should be in the ordinance. And putting in a base ordinance at a later date is the appropriate practice to remedy that omission.
Thank you.
Was the omission, conscious of what the city council said? Was there a purpose for the omission, or was it an oversight?
No, there was not a purpose for it. There's not a discussion, and there was not a determination to omit. It just was put in from what was expected to be in there, and what our zoning ordinance requires. Are there any other questions this time? I'm gonna check the iPad, make sure we're still streaming, and then be right back. Oh,
Our meeting has, so once we get to the work session, the information session is just for us to get background on the independent case, so that we're public, or the applicant can have it, but then once we get to the public hearing, we'll have an opportunity to hear from you. Thank you.
Commissioner Davis, being that you've been on the council longer than any of us, have you had experience with a planning development,
Yes, sir.
approving plan development?
Right, I do have experience with planning development let's wait, to discuss further until we're
Oh, boy.
in that open session of the meeting, but yeah.
So my question was more from this terms of, like with an SUP, there's a deadline, and about a similar kind of.
So I just had the plus.
So deadline is what?
Complex
Like
plans.
with an SUP, it's a deadline.
Oh, you're talking about how long you can endure.
Right.
Right, so planning development district, just topically, is, it's like zoning. So, planning development is saying, with this plan, we plan to develop this district in this way, these mix of uses. And so you will see at times
Yes.
that, typically, when one goes into a PD for land development district, there's a lot of thought and consideration input at what would be the uses allowed within that.
I think I did it. Because there was a-
As that district develops,
CO.
along its life and
Minus the control.
realize, you know, what it needs, what it doesn't need, this is what it is. Then you'll see the business come in and want to.
I'm gonna go into the other, we're gonna let's see if we're in the podcast.
And that's to add a use, restrict the use, change the use in PD. So then once you open the PD and make whatever changes and you close it, that's the zoning by right within that coverage area of that planned development district. So, that's, you know, ordinarily how they work. And so there's a fundamental difference between minor and major. And that's a question for staff, whether it sort of differentiates a minor from otherwise major meaning, that staff prefer that. But ordinarily you see changes, coming in, but, that's how they work.
Thank you.
Good evening. Today is Monday, September 23rd, 2024. This is a special call meeting of the Duncanville Planning and Zoning Commission. It is now 7:02 in the evening, and I hereby call this meeting to order. Colleagues, tonight we have but one public hearing item. It's listed number 4 on our agenda. Conduct a public hearing, but before we get started, I want to open the floor to any public comments. Now these public comments are related to anything not listed on tonight's agenda. If the item is listed on tonight's agenda, when we open the public hearing, you'll have an opportunity to speak. This is just general public comments. If there's anyone here wishing to speak on an item that's not listed on tonight's agenda, if you please come down and give us your name and your address, and you may begin your 2-minute comment period.
Thank you. Royce Miles, 623 South Alexander Avenue. My comments are about a lack of transparency in our local government. I recently received a letter from the city concerning an amendment to a plan developed asking whether or not I was in favor of granting the zoning request. What was missing from that letter was any details regarding the content of the ordinance. The city website has no details, but I finally found a statement in Focus Daily News.
Mr. Miles, I hate to stop you, but I must inquire. Just bear with me. Are you referring to item number 4, the notice on item number 4?
Yeah.
You spoke of a notice that you received on a public hearing for a planned development district. Is that the item that we're going to talk about here in just a moment?
Yes.
Okay.
But my
I know, Mr.
statement.
Miles. You were referring to item number 4 and what you perceive as insufficient notice or some issue that you take with the notice on this particular item. So what I'm going to do is just ask you to just hang tight for me, and we'll bring you back up when we get to item number 4, and you can be, because that's the item that we will be on at that time.
Okay, I
Yeah,
appreciate it.
absolutely, no problem.
Thank you.
Is there anyone here desiring to speak on the item not on tonight's agenda? All right, hearing none, Mr. Warren. We don't, well, I'm sorry, we have minutes. Commissioners, that was circulated in your agenda packets, I believe, Friday, the minutes from our last minute, for our last meeting. Thank you, colleague Columbus for chairing that meeting for us. Are there any other comments on that? And if not, I'll entertain a motion to approve those minutes as printed.
Motion to approve is granted.
All right, thank you, Commissioner Columbus, for your motion. Thank you for your second. All those voting in favor?
Aye.
All opposed? Any opposed? Motion carries. Thank you.
And who was the second on that motion? Thank you.
All right. Ms. Warren, we disposed of item number 3, so if you would take us away with item number 4.
Thank you. Item 4 is to conduct a public 2024-19 for consideration and action regarding the Monty Anderson applicant for an amendment of a planned development district on Wheatland Plaza Shopping Center, Block 1, Lot A, and Abandoned Alley, acreage 7.502, more commonly known as 42 East Wheatland Road, City of Duncanville, Dallas County, Texas. The request is to amend the existing zoning, being a P governed by ordinance number 2461. The future land use designation is retail commercial. This is an aerial of the subject site showing 402 East Wheatland Road, more commonly known as Wheatland Plaza, with First Presbyterian Church to the north, Reed Middle School, and Duncanville City Hall to the west, as well as residential neighborhood to the south and east. Here's a zoning image showing the subject being a PD and single family 7 to the south and east, single family 10 to the east, and further east along Lincoln Drive. The downtown development district to the west, including Armstrong Park and Duncanville City Hall. So this zoning request consists of 5 changes. These 5 changes are to section 2C, section 2C2, section 2R, section 2CC, and exhibit C. Section 2C aims to identify LOR as the base zoning district for the PD. Section 6.06 B2, B5 of the zoning ordinance, and that's the section found when defining plan development districts, requires selection of one conventional zoning zoning district to regulate all uses and development not identified as being modified. At the time of adoption, the ordinance did not identify a conventional zoning district as a base zoning district. This omission caused uses expected to be allowed by right to no longer be permitted under the new zoning regulations. Section C2, the request adds the following uses by right: child care facility, daycare, community center, public, library, lodge, or club. So all 4 of these uses are permitted in the LOR zoning district. However, a specific use permit is required for the lodge or civic club use. Section 2R aims to exclude residential development from the regulations of this section. It reads, all buildings over 1,000 square feet in ground area shall have a roof and a 3-foot parapet wall to screen rooftop equipment. All equipment must be set back 5 feet minimum from the exterior roof boundary. The proposed amendment would exclude this residential component from section 2R. Section 2CC would be a new section with added language that clarifies allowed uses within the plan development district. It reads, all uses permitted under the existing use chart at the time of this ordinance was adopted shall remain permissible for the duration of the development district. Any future uses added to the base zoning shall be permitted in the same manner as outlined in the base zoning. Suites within the plaza that have been previously occupied by a use permitted under this ordinance shall continue to be eligible for occupancy under that same use. New occupancy-related conditions or requirements shall not apply to suites previously occupied or listed under the current use chart as the adoption of this ordinance. And finally, Exhibit C, existing is shown. In red, you have a 3-story max of 40 in this multifamily housing boundary. In Exhibit C, proposed would be totally 2-story max, 30 feet. So going from half and half being 3-story, 40 feet, and 2-story, 30 feet, it would all be under 2-story max, 30 feet. Staff recommendation is approval. Thank you.
Thank you, Mr. Warren. At this time, is there anyone here desiring to speak on for or against item number 4 on this agenda? I think, so at this time, let's hear, if we would start, give us your name and address. If you, ma'am, if you just give me a second. Let's hear from the applicant and then we'll take.
Wait, why does he get to go first? He's not a citizen.
Well, first of all,
He is not being
ma'am,
affected.
what we have to
We
do
are.
is maintain the form, okay? So, as the applicant, and as the chair of the meeting, I'm gonna allow the applicant to go first to give us their same amount. We're gonna give each side a total in the first round of 5 minutes, Mr. Moore. And so, you're gonna keep time. We're gonna do this decent and in order. And at this time, so once you're in place, ready to go, we're gonna hear from the applicant, and then everybody else will have the same amount of time to come forward and share any objection they have to the zoning application. And that's the way the process works. I mean, we're gonna hear both sides, and everyone's gonna get the same amount of time. So I appreciate your decorum and your cooperation. Mr. Warren, are you ready?
I am.
All right, could you give us your name and address?
My name is Monty Anderson, 1210 Greenleaf, we're in Duncanville, our residence, I'm the owner of the plaza. And the main thing that's going on here, the reason that we came back is because when you file a zoning application in Duncanville, you have to have a base start from the LOR, which we did. So it means the LOR is still there, and it allows the things that you do. You have to have that. That's the rule here in Duncanville. That was in the zoning document that I got back. That it said that LOR plus the PD. Well, when that document actually got signed, there's a mistake in that because it's LOR was not allowed, was not. So it goes against, it actually goes against what's required by Duncanville. So the reason I came back was to fix that. Okay, because that's the way you require it. You require us to have the base zoning, and then we go from there on top of that. So the uses, childcare, community center, public, and library are all allowed in LOR. Okay? And the other one, the lodge or civic club is by SUP. Let's keep that as SUP, that's fine with me. Just keep it as an SUP. We can bring that up. We don't have it now.
Could you make that last statement again?
Excuse me?
What was that last statement you just made?
The lodge or civic
Oh,
club
okay.
that we talked about, it's required SUP.
Mhm.
You can keep that.
Okay.
We don't have to have it on the other three. So what I'm asking for is to fix, first of all, to fix what was wrong. Because that's what your requirement is. Okay, second thing is on the non-residential unit and the changing, I thought I was doing a good thing. We got 51 units approved in our original zoning, in our PD. We can build 51 units currently, the way it is right now. And in the purple area, allowed us to go 3 stories up on the front, and then 2 stories in the back. And we decided that we heard from people, and we thought about it. We lowered everything down to 2 stories. So we did that. We don't have to do that today. We're doing that. We're just saying, in case something happens to me and I'm gone, it's down to 2 stories. And also, it went from 51 units down to 16 units. So there would be more green space. We're going, that's not part of this zoning, but the 2-story lowers that down. It actually decreases the density, I would think it makes it better. I would rather see that. So those are the only thing, that was just a cleanup. The first thing is to clean up, I think, what was a mistake, okay? And the second thing is to make the project better. And as you can see by evidence of our project, we started at 28% occupied when we were up there today. We're at 88% leased. And we're also doing, huge amounts of landscaping across the front. If you've driven by there lately, you're going to see wide areas where we're doing what I feel is really a lot of good stuff. And, so I don't know if there's anything else, but that is really, what's really, I guess the other issue is the parapet on what are going to be the towns. They're going to be for sale townhomes. They're not going to be for rent. They're going to be for sale townhomes. And that was so we could build a pitched roof, or slightly pitched. The only reason we're asking for a change there. And, with equipment would be on the ground. When you have a pitched roof, there wouldn't be anything on the top. But these units are going to sell for, they're going to sell for over $300 a square foot. So they're not cheap units. We're not putting in, cheap rental units of any kind there. So that's really all I have, and really it's just a cleanup of something that shouldn't have happened. So with that, I'll answer any questions or.
Yeah, if you just stand by, Mr. Anderson, we're going to get through our other speakers, and I'm quite sure staff will be back. I'm sure my colleagues will have questions for you, so if you just hang tight. All right, anyone else here desiring to speak to this application? In support of it?
Yes.
Okay. Seeing no one else here desiring to speak in support of this application, at this time, I will ask that you all come up and give us your address and begin your comments.
Hello, Council. This is my first time running into many meetings with the city councilors and the mayor. My name is Teresa Montgomery, and I live at 519 Allen Avenue in Duncanville. and I'm exactly around 15 to 20 feet behind this project. So I've been affected, I've been here for 25 in the same location. And my concern with this project is that, I believe I talked to them, when it started, which was 2021, I believe when it was approved. And it was a totally different panel that he sold this dream, that no longer exists and understand what the intent is. It has changed several times. Some of it has not been run through you, you took it upon yourself to change it. I'm asking you to deny this amendment. First, we received grant money under the first one to have this project. So on that note, it's not just his personal money, the city has money as well. And this zoning change is not benefiting the citizens of my community, it's not. I have a petition that I sent in to the councilors, the mayor, the management, 30 people that are not here for one, they're being, embarrassed or humiliated or not understanding the lingo that, you guys have, so they're afraid to come here because they don't understand it, and some of it I did not either. We have been presented that it's not clear, and today it still isn't clear. He's wanting another apartment complex in the center of businesses who are already struggling for parking. He's already changed the parking, by taking down grass and trees are beautiful, I love them. But this was a community where we sat with fireworks and parades. We can't do that. And every time that I've come in front of Monte Anderson, he quickly reminds everyone he was supposed to be deaf. It's my private property. I can do what I want to do. So these tantrums are not accepted by me. And the daycare that's going there, it's within 1,000 feet of a gun shop, and they keep on omitting to let you know that on the backside of Duncanville, there's a gun shop. He's putting a daycare there. At the other end, there's supposed to be SWAT, which is an education institute. Again, it's a college setting. There's a gun shop that's within 1,000 feet from there. Texas law says that you can't have it there. A school across the street, 840-something feet away from where this gun shop is. He cannot continue coming here and cause this threats in our business, in our neighborhoods. I worked hard to keep my kids away from the environment that offers guns, tattoos, liquor stores, and I'm not going to stand by and allow it to happen now in my latter years when I'm supposed to be able to sit on my couch and take a nap, sleep peacefully at night. This lodging that he wants to put in there, we had a question, well, how are you going to screen the people that you come in, that come in? You're not a hotel. We have those around. The lodging should not be allowed to happen there at all, period. So you want boarding houses inside of this building? No way. No way. It's not going to happen. So the zone, the amendment, I'm asking you to deny it because it's not any more beneficial than what he had presented to the first council that approved this list.
Thank you, Ms. Montgomery. Next speaker, please.
Royce Milam, 623 South Alexander Avenue. This is a rather complicated situation, and I was speaking at first because there is a lack of transparency as to the plans for Wheaton Plaza. And I had to put two and two together in order to figure out what I thought tonight's planning and zoning session was going to be about. And I made a 2-minute statement dealing with that I put together thinking it was just. I hear from Monty Anderson tonight that dropping it from 3 stories to 2 stories, that there'll be less residents, more landscaping, more available parking, which was a difficulty associated with the.
Thank you. I think if we can 3 more minutes.
Okay, yeah.
If I get my colleagues to support a motion, I move. If someone can support a motion to move to add 3 minutes to both sides. to both sides, both for and against, 3 additional minutes, so make sure we can hear the rest of Mr. Milam's, remarks, as well as I know we have another speaker, thereafter, so. That's the motion, someone can second that.
Second.
Okay, it's been moved and seconded to add 3 minutes on both sides, all those in favor say aye.
Aye.
Any opposed? All right, continue.
Thank you. I'm actually in favor of it being, the apartment complex in the center, being 2 stories as opposed to 3, because I was privy to the details a while back, and when plans changed, Bonnie Anderson, and he decided to go with 3 stories and this development, the landscaping was going to be less than the 20% required by the city ordinances. And in fact, it was only going to be about 5% of the property landscape, and that bothered me tremendously. And also there was going to be continual parking difficulty, which as a resident, I was not interested in. So my comments that are not about this zoning session, I would still like to read the 2 minutes statement.
Oh, okay, well, I tell you what, Mr. Milam, if you hang tight, I want to reserve the time. If you have, so when we first started our conversation, your comments were around the notice of this. Now, if you have other general comments, I would prefer, and I hope you're not on my time, my time is not running. I prefer, if you have other general comments, I prefer for us to hear from our next speaker, and then we can go back, revisit the public hearing, come in, and if you have a 2-minute prepared speech that's general and not on item number 4, I'm more than, so which is it?
It is both. Because it's about the abandoned alleyway,
Okay,
which is.
so let's do it this way, I think that you've expressed the majority of your concerns, as you prepared for on item number 4. Let us hear from the other speakers,
Okay.
and then we can come back at your general comments, as it relates to, and we can tag that on to item number 2.
Okay.
Okay, thank you.
Hi, I am Julie Whitman. Address is 515 Allen Ave. Right behind all of this that's going on. First of all, the alleyway is not abandoned. Quite frankly, I am tired of getting his trash because his contractors aren't getting their screen up along the fence to keep it private like they have been told to do by the city. On top of that, within a 5-minute drive from my house, which is directly behind his, we have 6 apartment complexes. Why do we need a 7th in the parking lot? We have 6 hotels in a 5-minute drive. My issue is I have an 8-year-old daughter that loves to play in the backyard. My problem is I can't do that. His workers have completely stopped work to watch my daughter swim in a swimming pool. I am starting to have an issue with this. Then I find out he wants to put hotel rooms inside his buildings. Well, how are we going to keep the pedophiles out? We can't do background checks. We can allow daycare and this hotel right there within of each other? Really? Are we really stopping to think about our kids? When I'm here, I have to think about my daughter first. I get it. Y'all get to think money first. It's the city. But I have to think of the safety of my daughters. And I have not seen anything from Mr. Moe and these hotels that can promise the safety of my child. I am literally 20 feet from his property. I look out my back door and I see his property with a chain link fence. There's no private. That wasn't my time, that was still his, so I'm gonna still go.
What happened to me as well.
So, you know, the other side of the street, they at least have a brick wall. I don't, you're gonna put apartment complexes in that get to look down into my back on my daughter in her swimming suit? Really? You think this is an appropriate place to put an apartment? Are we really considering an apartment here? Are we really saying it's safe to have that close to our elementary schools, our intermediate schools? I mean, is this really what Duncanville wants to be about? We keep taking everything away from the kids, but we can't seem to give it back. You know, there's so much stuff that could be used in Mr. Moat's stuff. I mean, we can put amusement things in there for our kids. Why can't we have something, some kind of indoor playground for our kids there? Why do we have to have a gun shop? Okay.
Thank you.
Oh, by the way.
Anyone else? I'm sorry.
That alley is not abandoned.
I'm sorry. We try to make sure that we can conduct our meetings, with decorum. We try. All right, I don't see any other speakers here. I want to start questions before I get to my questions, if you don't mind. I want to start questions from staff. Mr. Moore. Mr. Warren, is there there was not in our agenda packet, I'm going to start at the base. There was not in our commissioner's agenda packet, ordinance 2461R that's before us and I appreciate you giving me a copy with the marked up differences so I can be able to see what's before us tonight. What was the previous ordinance that created this PD back in 2021? What was that number?
The ordinance was 2461, I believe. 2461.
All right, and so this particular, so the text as amended will kind of read anywhere it's been changed from its original, right?
Yes.
Okay. So as I peruse through the original language of the PD, and in full disclosure, because of another life I've had in board and commission service, I remember this particular case very, very intimately. So the base was LOR. Was it missing in the original document that creates this conversation about what's missing versus where was it missing?
So it would have been section 2. However, it has signed, it does not reference it anywhere a base zoning district.
Was section C, 2C in place,
Yes, section 2C was in place.
which is out the uses?
It does, and let me get to it. So I'll make it better. So section 2C lists in its entirety all the uses within the PD that are permitted.
But, so while the original document had PD language about uses, it did not establish a base.
That's correct.
Correct. So comes under C2, I, J, K, and L, in effect, childcare facilities / daycare, community centers, public library, lodge, or civic club are the uses that this commission is asking to amend.
That's right.
Okay, got you. Item number R, all non-residential buildings. Did it used to just say all buildings?
That's right.
Okay. And in fairness to the fact, most commercial buildings or buildings with flat roofs, it's more desirable to have a parapet screening their utilities. So there won't be that eyesore. Is that a correct point?
Yes.
Okay. So by changing the roof structure, you would then need to deal with, I guess, the utilities or the parapet wall differently. And so I make we distinguish between residential, because it never occurred before, and I'm just trying to walk through what are the changes.
That's correct. So if a non-residential building were not to be flat, to have a pitched roof, then section 2R would require amendment.
Right, okay, so I just wanna make sure I'm tracking there. Then I come on down to CC, and you described it, I think, in your reading in of the case of the record, is a clarification of some things, and I'm not gonna go through that line by line, but I'll get to that a little later. Then when we look at, I just wanna go over for my colleagues' benefit, you know, what's the layout, what's different in the actual zoning ordinance document. So then we get to exhibit 11 and 12. And this will facilitate what the applicant has requested in terms of apartments in the center and what we've heard some other comments on. What Tim explained to me, I know we're dealing with some height here. And so we're restricting it in some cases, but it doesn't seem to be changing in others when I look at the legend. So walk me through what's the difference between exhibit 11 and 12, because when we read that in and clarify, that's all a part of this request. And so I want to see what I'm not seeing in these exhibits in terms of height in particular, is what I suspect.
Yes, so, existing, exhibit C shows.
Which is C? Oh, yeah, that's at the top, okay. All right,
The,
page 11, okay.
Yes, it's slided on the PowerPoint, it's the exhibit, second to last page of ordinance number.
So we're going to,
6-1.
we would call these sub areas, right?
Yes,
We would call sub areas. So when I look at the chart, I don't see any change. I see colors have changed, but what's happening here? Make me understand the difference.
yeah, so the difference is that the two-story max on 30 will be for the entirety of the multifamily housing boundary, whereas previously adopted, Exhibit C showed a 3-story max of 40 feet at the front, being the northernmost portion of the multifamily housing boundary, and now it's a continuous 2-story max of 30 feet.
So the net effect is we moved 40 over east. I mean, it's always been there, but we just drew the line more easterly, right? And we expanded more, what would that be, south. We swapped, right? We swapped the 40 with the 30.
A 30 engulfed the entire area. So what was previously,
That 40 ran all the way back over to the other one-story buildings. That 40 ran all the way across.
right, sub-area 2A is in red, and it's from the,
So we took that out the middle and we went 30 going back up towards the back.
yes, towards Wheeling Road.
Towards the front there.
Yes.
Oh, I was disoriented. You should have told me that. Oh, so. So we lived
Is to the north.
to the north.
And now it is proposed to be 30 feet in its entirety, rather than
40.
40 and 30. Now it's all 30.
Okay. My last technical question, thank you for walking me through that. My last technical question for you, Mr. Warren, is, from staff's perspective, the difference between a minor amendment to a PD versus something more than that?
So a minor amendment to a PD is, there's, I believe, 8 qualifiers. This would not qualify as a minor amendment because it is a matter of land use and zoning being changed. Therefore, must go through 2 public hearings, being the Planning and Zoning Commission and the City Council.
Right.
To get approval. A minor amendment has the opportunity to be approved administratively.
Okay. Did we refer to it as a minor amendment staff report?
We did not, however, the applicant in a letter did use the verbiage.
Okay.
Minor amendment, not technically minor amendment. I believe the intent, assuming, is that it was not a major amendment.
Is there a site plan, requirement in this PD for all these other things that we hear about? Because I know there was some objection to a site plan once before because everything was too fluid. Is there a site plan being offered up for some of this?
So there is not change to the existing site plan, which is the existing unit.
11 and 12. See, whatever those two we went through at the end. Yeah.
Those are that's the sub-area exhibit. There's exhibit B, which is the public development map.
Could you point my attention to that? Because I don't.
It is part of the back,
Okay.
and it's part of the ordinance.
Okay. All right. Well, I'll get off the air for a moment. Any colleagues have any questions for Mr. Warren? Okay. All right. Thank you, Mr. Warren. Any questions for you? Commissioner Columbus? Well, let's give the applicants some time.
So in section of its 2R, it mentions that all tenants that are currently there will be basically grandfathered in. The question is, if the amendment is approved today, would there be any existing tenant that would meet the requirements of the agreement?
I don't understand that.
Ms. Columbus, Commissioner Columbus, Mr. Anderson was asking you a good question. You talked about in the request that staff has accepted as or recommended approval outright. If existing tenants who do not comply with any of the zoning regulations within this planned development street would be given, basically, given conforming status, in so many words. So, Commissioner Columbus, Mr. Anderson, the question for you was, how many businesses, if this was passed today, could meet it without this issue?
A bit of housekeeping. Our mics are being projected into another meeting. Therefore, we're going to have to go off mic and project our voices. I apologize for the.
Did you hear my question? My question,
Yes.
Commissioner Columbus' question.
Yes, that's the question.
Yeah, I don't think we have any that are non-conforming.
No, that wasn't the question. She was saying that because you asked for in your application, you asked that any existing suites within, I'm giving verbatim, suites within Wheatland Plaza that have been previously occupied by use permit under this ordinance shall continue to be eligible for occupancy under the same use. That question, for Commissioner Columbus made her ask, if we pass this today, are there any operators who, without this provision, would meet the requirements otherwise?
Are there any operators that wouldn't be, if you didn't pass this, are there any operators that wouldn't? I'm sorry, I don't understand.
So it's necessary.
Why is this necessary?
Why is that particular clause necessary if all businesses can comply with regulations otherwise? Let me ask that.
Basically, it's just cleaning up. When we did the initial zoning, LOR zoning, that was the base, that was what was approved, and that's what was in the document.
Yes.
That covered, right now, there are no occupants in this space, in any of the spaces that need this.
So is that fair to say you don't really need that provision then?
Section 2R. Or 2CC.
2CC.
Sorry.
I don't know, I think this is just basically clearing up any.
Today that all the businesses within this PD otherwise meet because they were LOR and they are operating with them.
Yes.
Okay, so this sentence is not necessarily necessary, is what I'm hearing you say.
I don't think so, but
Okay.
I'm standing here without a planner, my attorney, or those kind of things, so I don't believe it needs that.
There's none without any, there's also that an issue. Okay, thank you.
I want to say something too, just on lodge, that's not lodging. Lodge, that seems like it.
Well, I think, Mr. Anderson, I think that, of course, there's some overlap of language talking about lodging, civic lodge and that kind of thing. But I think that, I heard you saying that, you know, you were totally fine with that remaining under SUP, and all of that, but I was of that same mind. I said, well, maybe we're getting some things confused, but if as I kept listening, lodging was referring to the hotel use. When I kept listening for the context, I don't think they were talking about a lodge, you know, like a lodge or any other use that, they were talking about the lodging and, you know, people being in and out and the transient nature of lodging, and what potential impact that could be. That's what I heard, so I just wanted to respond to this since you brought that up. Okay. Commissioners, any other questions for Mr. Anderson while we have?
Yes, I have a question. Mr.
Sure.
Anderson.
Yes, ma'am.
Earlier you said that, because I need some more clarification on exactly that, the lodging. But you said that these will be homes. And they're homes and apartments?
No, there's no apartments, it's townhomes.
Or townhomes? They're townhomes.
They're for townhomes.
They're for townhomes that are on the Wheatland side. On the Wheatland side.
Yeah, they're in the interior. Could you pull up the map? There's nothing being built.
And particularly, I think at this point, because I don't know what the map we're referring to, can we pull up a site plan?
It's a site plan.
That's it?
Yeah, that's it. That's the site plan. So the yellow, just so we're clear, because I saw some confusion, the Wheatland Road is on. Okay.
That was me, but I'm clear now.
Excuse me?
Yeah, that was me. I was confused at first, but I'm not anymore.
So the yellow buildings, or you know, the U-shaped yellow building around the outside, it's already there. So it's mostly yellow, except it's red top left-hand corner. That's where Domino's Pizza is, the donut shop. So nothing being built behind the building to look into anybody's building. Nothing at all. And it's not, we wouldn't be allowed anyway, it doesn't meet the setbacks, it wouldn't work. Everything that's being built is in, you see in the purple, those shaded structures there, they're shaded. That's the apartment that got approved for multifamily for 51 units, which were intended always to be sold. They were gonna be like condos. So we downsized that, to 16 units to townhomes. And we downsized the height. So you can't build 3-story up on the front anymore. I mean, we did this, we did this, we thought is a benefit. We thought it's lower density, less parking, more landscaping. We did this as a benefit in case not here in the future. This is built. So as we got to looking at the site plan, looking at the project, what we can do to make the project the best it could be, that's what we decided to do. So those are all in the interior. And if you look out there right now, if you drive by there, you'll see the food trays out there. There's a big square out there in the middle that's not striped. And that's where that area goes. And we do meet the parking requirements. We do have a parking study. So of course we have to meet the parking requirements anyway going forward. Every time we get a certificate of occupancy or building, we have to meet the parking.
Mr. Anderson, is it safe to say that at this point in the condition that this site plan is before us, you really can do any of the uses, and the only thing, you can do any of the uses that you're requesting in any of these boxes. The only thing that this plan does is cap height.
The only thing this plan does is cap the heights. I mean, this.
That wasn't what I asked.
I don't understand.
Okay, I'm asking perhaps a bit different.
Mr. Chairman, I just want to make sure I finished answering. So Brian, did I finish answering?
No, not really. Because on the map where you have it in purple, and then the side square, the rectangle, and then the shaded one, where you're gonna have the units, and then the pink area, and according to your schematic, you have the three-story max of 40?
Yeah, that was already there, and I don't even know why we need that there. In fact, if we could, you could just make everything purple. So, no, we're not gonna, we never plan.
What do you mean we can make everything purple?
Well, that orange says.
Are you amending the application? I'm confused.
No, I'm just saying if you want to, I'm amending anything.
Oh,
Just like I said on the SUP a minute ago, if you want to make that SUP, I'll concede to that, it's fine. But if, right now, it has across that red, if you go back, clear back to this is the original, the existing, see, the way it is right now. Right now, see all the red area up there, I can build, that's up against Wheatland Road, I can build 3 stories up there. So over the top of those pizza, over there, and all the way across, I can go up to 3 stories, 40 feet. So what I'm amending, what I'm doing is changing the part we're gonna build down to 2 stories. If you say you want it to be 2 stories and 30 feet on the whole site, I'm okay with that, because I never plan to build 3 stories. That's my only comment to her.
Does that answer your question, Commissioner O'Brien?
Yes, so what you're saying is that this is your local, as far as what you changed, as far as where the original red or pink area, as you described it, was currently is. But you're saying that you're flexible in the fact that you can go from that red or pink area of a max of 40 to the purple area where it's 2-story at a max of 30.
Yes. I would flex down to benefit the lower.
That answers my question.
All right, thank you.
So that would mean I could never build 3 stories, always would be 2 or less.
That's currently around there now, as far as story height, matching the general, dynamics of the neighborhood. We are taking that into consideration, as far as, the aesthetics and how it changes the aesthetic of that neighborhood. Because if it's a 2-story building, I'm not quite sure how that lines up with the general aesthetics and how it changes.
We don't have to change that part of the zoning if you don't want to at all. What I did instead of when I came in, when this came back up, what I thought is, while we're doing this, I had already decided to make it look, so it looked better. Okay, so it's better going, so it didn't stick up so much. So I had already decided to do that. So because of the neighborhood, because I bothered me because it was connected to the neighborhood. So I like this property because Acton Street connects to the neighborhood. The parking lot going through my property is not Acton Street. It's not a public street. It's a private property. And I bought this property here because it connected to the neighborhood. Because this would become walkable. This would become a walkable place where people in the neighborhood can have something decent to walk to eat, to shop, to do whatever, to take care of, do those things. And that neighborhood is important to me. And in fact, the stuff in the back, the alleys, I don't know. The Encore alleys and those, I don't own them. Okay, that's not my property. But I clean them. And I mow 2/3. I take care of all of that land. So, even though it's not mine, it's not my property. It belongs to mine. So, I don't intend to do anything to hurt anybody. I would have thought what I've done to this property so far was been good. I don't understand. I really don't understand.
Thank you.
So,
Thank you. Does that cure your question?
Yes.
Okay, I'm waiting an answer to mine.
okay, so I'm sorry. I just want to make sure.
Yeah, you're fine. I'm waiting.
What was your question?
My question was, other than limit or cap story height, what else does this site plan assure this body or the community of what will be exactly there and what it will exactly look like and and to Commissioner O'Brien's question, give some insight into how it will interact and what the settings will be for the neighborhood, considering that in effect, what we're asking neighbors to do is be comfortable with from one story nearest their home to, in some cases, up to 40 feet. And in the second most voluminous place is 30. So, not to complicate the question, just very simply, outside of story height, does this site plan do anything else to ensure and or govern future development, to your point, if something happens to you tomorrow?
I mean, the
Other than the uses, no, I'm talking about where things are located and how they look.
The PD, from day one, this site plan is part of the PD. So you can't just go into the site plan. I'm sticking, this site plan has not changed from my very first submission to this body here to the city council. The site plan has not changed.
Oh, no, I'm not suggesting that. I'm asking you what assurances, guarantees.
The PD is one assurance because the site plan is part of the PD.
Outside of, what does this site plan do other than cap height?
The site plan shows where you can build stuff, what you can do with it. It shows where the landscaping's got to be. All of that's part of the site plan. Also, the agreement with Duncanville Development Corporation, there's also certain agreements which are things like fixing the building, fixing the roofs, doing all the land, doing the repairs on the apartment, removing all the asbestos out. I gave her a presentation just a couple of weeks ago over the new coal well, okay, to the Economic Development City Council. And we went through the 7 points on the checklist, and all of them were done, except for one thing, the landscaping in the front. And the only reason that wasn't done is because I didn't have a permit from the city yet. It took me a year to get a permit.
Thank you, Mr. Anderson.
So,
You answered my question, thank you. Colleagues, any other questions for, yeah? All right, thank you. Any questions for the opposition? Anyone in the opposition? No, Ms. Montgomery, I actually have a question for you.
Okay.
If you come forward. In your comment, you expressed some uncertainty and some concerns that some neighbors did. My question to you is, since you live in such near proximity, what kind of formal neighborhood outreach to kind of, share as we come along and being such near neighbors has been put forward even in advance of this particular amendment application?
As far as neighbors that I've spoken to.
The applicant reaching out to you all in the neighborhood to formally
Yeah.
and
Well,
successfully
I
understand and
have
address your
been
concern.
elected to speak on their behalf, by way of petition.
Then in your comments, my question to you, Ms. Montgomery, is what in terms of outreach and communication has the applicant extended understanding the concerns?
I had a private meeting with him and Councilman Coops and also Good, where we walked around for him to explain what his intent was, he had already accomplished. And we spent about an hour and a half doing that. We also did another meeting at his location on the inside where he was able to speak with all of the panel from council, mayor, and everything. And again, he's explaining with very limited information again. A lot of things was omitted, a lot of things like brushed over so that it didn't really clarify his exact intent. So that would probably excuse him later on in the future to say, well, you didn't ask. So people think that because it's not written or they don't express it, that it gives them a roll out temporary to do what they want to do, and that's what's been happening. So if you don't hold them accountable, because I've had the council go over this ordinance, because even reading the ordinance in 6.02C, there is no set specifics that he has or anyone that comes before planning. It doesn't tell you that you have to list this, and you have to, list this, you have to show this when you're making these amendments or even requesting these, type of upgrades in the community. So they are going to look this over with the with lawyers and find out how they can amend that ordinance, because it kind of does allow him to do what he wants with his job. It's not specific on what he can't do, what he has to list or not list. So the ambiguous language is free for all.
Thank you, Ms. Montgomery. Colleagues, reading in opposition. Any questions for staff comments?
I have a question.
Mr. Wynn, if you give Mr. Moore some time.
I noticed that when you were talking, we started off with the LOR. My only question is, the concern was that there was something that was not addressed, such that it was an omission, and this was a way to fix that. So my question is that if this, if the request for this base zoning information had been included, is there any difference between what is being requested now versus what he would have been able to do if that issue had been actually in the original request?
Yes, so looking at the ordinance, which is ordinance 2461, in section 2C is where the allowed uses within the PD are listed. And it's divided into 5 sections. There's 1 that's residential, 2 that's educational and institutional, public, and special uses, 3 recreational and entertainment uses, 4 retail and service uses, and then 5 automotive and transport uses. And the uses that are permitted are listed. That is how verbatim the ordinance reads. Typically, in a plan development district, as governed by section 6.02B2B5, there ought to be a conventional zoning district as a base zoning district. And this is to default when there's something that's silent. So let's say, for example, just find one, okay, in portion L of section E, or part E, section 2E, or section 2L, says up to 45% max lot coverage will be allowed to incorporate the proposed housing in new commercial development. There's a different maximum lot coverage in a basin or in LOR. If there wasn't that section, it would refer to the base regulations in LOR. It's kind of a long-winded way to say.
What a more, I'm sorry,
It
it's
is.
the Bible. What a more way, on a layman's way of explaining it, Mr. Warren, be that everything must be zoned. A PD allows for many different collective uses and many different zoning potential uses, but at the end of the day, it has to fall back to one and it must be expressly stated. Does that answer your question, Commissioner?
No, because what I'm trying to find out is that I'm trying to see what's the difference between what this says and what he should have gotten, and he did not get it, such that he had to come back to ask for it.
Right, so previously, before the PD was adopted, the base, or existing zoning was LOR. It was already LOR, and all of the uses allowed on the use chart for LOR were permitted by right, or if there needed to be an SCP, they were part of an SCP. However, when this ordinance was adopted, only the uses that were called out are now permitted. Therefore, if they didn't list that exact use, example, child care facility daycare, they're no longer permitted to operate. And previously, they were allowed to operate under LOR. Now, the applicant expected to be allowed to operate under the base zoning district of LR. In addition to the changes in the PD, the fixes in the PD, the modifications in the PD. However, that base zoning, that conventional zoning district was not identified in the ordinance. Therefore, I would attest that that's the most important piece of this request.
So along that most important piece of request, train of thought, how were or do you know the original, because coming to the table, everything in LOR was on the table.
Yes.
And through conversations and meetings and planning, certain uses were stricken. And can you make a development happen with this or without this, that kind of thing? Are you aware of any of that deliberation of work that happened?
Yeah, it was a lot of deliberation about
I'm talking
many items,
particularly
not
the
just
uses.
use. Okay. Particular to uses, there was a idea or thought that the base zoning would be eligible. It is, right and omission of a base zoning district.
Is it the omission of a base zoning district, or is it the omission of referencing the zoning district in addition to that were agreed to be not within this particular zoning district, in this particular planned development district? Because I don't want us to conflate the two.
Right, and they are very different.
But so,
So, the LOR uses were intended to be part of this PD. They were omitted.
so are you saying all LOR uses were omitted from this PD when it was by council? Is that what you have?
All uses that are not explicitly written in section 2
That's right.
are not permitted.
So have done any investigation as to why certain uses that would be permitted in LOR are within this planning development district as adopted by council?
Yes,
Why?
because there's not a base zoning district, and I don't have the smoking gun as to why this omission occurred, but there needs to be a conventional zoning district and,
I agree with you, Mr. Warren, but I think where you and I are not on the same wavelength is, I understand it's not as a particular base zoning listed within this, but I set that aside. Every planned development district needs some type of base zoning, if you want to call it whatever, or, whatever the base zoning is, and then you put certain uses in, you take certain uses out. You could have, LO in certain cities, you could have, MF3 that allows for more intrusive use, and you say, I don't want these, but I need to be able to have some of these other uses. And so when it comes to the other end, it's going to reference the base zoning, but you'll notice that certain things are not allowed. And in some cities, they'll people do a strike through, so there's no confusion about what's in the zoning district and out of the zoning district. So what I guess I'm trying to understand from you is, I have a collection of certain uses that are permitted within LOR, the applicant agreeing to not having those within that particular plan development. So I'm bifurcating between omission of base zoning and the exclusion of certain uses within that base zoning.
yes. I would say that there was a omission, and if I'm getting the terminology correct, the exclusion of particular uses were the base use LOR are either reflected in
Hold on, I'll move on because I got another question. In CC of some, these pages are numbered, that's me another disadvantage. CC, I think there are about 4 sentences here within what's added, kind of this catch-all language. There are sentences here. All uses permitted under this existing use chart at time of the ordinance adopted shall remain permissible for the duration of the planned development district. In what instance would this not be true? I'm doing a necessity test.
It would always be true.
That would always be true, so is this sentence necessary?
No.
Second sentence, any future uses added to the base zoning shall be permitted in the same manner as outlined in the base zoning. When would that not be the case?
No.
So is that sentence needed?
No.
No. Third sentence, suites within Wheatland Plaza that have been previously occupied by use from this ordinance shall continue to be eligible for occupancy under the same use. Would that be an issue?
So it would possibly be an issue if you determine non-conforming, and then after a period of 6 months, again,
The non-conforming rights would lapse.
correct.
But we heard Mr. Anderson testify earlier that there are no businesses within that planned development district that are in non-conformance.
I heard that.
So would that sentence be ever needed or necessary?
No.
So it could be removed.
Yes.
Last. Newly occupancy-related conditions or rights shall not apply to suites previously occupied or listed under use chart as the adoption of this ordinance. Notwithstanding the conflictual nature of the last sentence 3 and sentence 4 in my mind, can you explain to me when this would be a topic of action? Or I'm just trying to see, because one says they will comply, and the other says if you don't. I don't know if it's belt and suspenders. I'm not real sure. I'm trying to understand the necessity of the last sentence since we've strengthened the first 3.
I cannot
You cannot, what?
offer a fence for section.
So is it necessary?
No.
So is it fair to consider all
It is fair. It's fair to consider striking any or all.
of? I know, but I wanted to understand. Staff recommended approval, and you all are the experts, and so we don't have the skill or need to work zoning cases as they come in. So I'm just, if you all recommended approval, I wanted to just kind of walk through and understand, is it necessary, what the approval is based on, and if something I'm missing. Commissioner Columbus, thank you, Mr. Moore. Commissioner Columbus.
So my question was, the original ordinance didn't include a base zone, it did include very specific uses. What other zoning was considered that they have covered these uses that are listed?
What uses?
So these
What-
uses that are currently listed says the residential, and there's 3, agency, and institutional, public and special uses. Are there other zoning besides the LOR where those uses are included?
Yes.
And there are many.
Yes.
So my question is, if there are other uses, why that where those are included, and these 4 uses weren't included in the original ordinance, why is the LOR the one that's chosen?
So, the 4 uses, I'll go to that slide. So the 4 uses that are shown, 3 of them, childcare facility, daycare, community center, public, and library, are permitted by right in LOR. These 3 would not be necessary if the section 2C were adopted. The language in section 2C identifying LOR as the base zoning. So it's by nature repetitive. However, there are other uses that are also repeated in a base LOR in the existing zoning. So it tracks with the existing PD. Not to say that those uses are not to be struck in or left in, but it's consistent that there was an idea that LOR would be the base zoning, and then there would be a list of additional uses.
Is it possible that the intent was to restrict or remove these 4 uses because of tenants, or like these 4 uses intentionally
anything is possible, however, they're not currently on the list. That's how it stands today.
Well,
But
let me ask
if
you
there
that.
makes some LOR, they would be permitted.
On that note, let me ask you this. When someone in the city of Duncanville requests a planned development district and they identify uses that they don't need, how does it appear in the ordinance?
Inflated and.
No. I said, how does it appear in the ordinance?
How does it appear?
Uh-huh. Like say I come in and I want planned development district 2462 T. And I said, you know what? I'm never gonna need a concrete batch plant, although it's allowed by right, I'm not gonna need a truck yard. All I wanna be able to do this is only permitted in this zoning regulation, or it's not, but I wanna convince my neighbors that this should be an allowed use, and therefore I'm carving out this special zoning. I'm gonna ask for certain exceptions and carve out to make this happen. How is that shown on that governing document that's by the city secretary? How is that use shown as permitted or not on that ordinance?
It would be explicitly called out as not permitted.
And
So it
explicitly
would
called out
say,
as
it
not
would say
permitted.
there would be a base zoning, let's say, daycare is that's permitted in LOR, that has been negotiated and that is not going to be part of the planned development district. It would state that there's a base zoning district of LOR excluding the use. However, there are no uses that are excluded in section 2. There are no such uses.
Okay, that's why I'm just trying to understand how we strike through them.
In Dallas,
I'm just
we
saying-
would state and then say we would explicitly call out the
Well,
exclusion of them.
Okay, and I just want to make sure that maybe in Duncanville, they just don't list them, or they call out a different,
Right,
like,
as a veteran of writing ordinances in the city of Dallas.
That's what I thought
the
I
way
had.
it
And as a veteran of reading them, I just want to make sure I wouldn't miss it. Okay, that helps.
Thank you for that, because I was assuming that in Duncanville, they didn't list them.
Right. That's why I just heard your question. I thought, let me just go, okay, all right.
That's it.
Okay,
I still have a question.
Commissioner O'Brien, that's fine.
In your opinion, would you find the verbiage in this package that you presented to us? I missed.
Some,
Okay.
so section 2CC, I think, would, yeah.
Okay, so in taking into consideration the concerns of the citizens, one of the things the citizen didn't talk about was the ambiguous nature of the verbiage located in this package, which made it very difficult to interpret what they were reading or not reading. And just sitting there listening to the commissioners break down what is being said, and then realizing that quite a bit of it can be stuck in it wasn't important in the first place. So therefore, with how and all this it leads somebody down the path of what are you talking about? Okay, so when you're explaining something like this to a person that is getting ready to have their neighborhood modified, it needs to be understood in a way that they can metabolize it in their own language. So this I found being broken down and deconstructed, and it's down to nothing. So that gives me pause for concern about it can, how do you say, misconstrued as double talk. And you agree to something that you don't understand, which is a very difficult thing to do. You gotta understand what it is you're agreeing to before you agree to it. And so all aspects of what is being proposed needs to be put down and presented in a manner that is digestible by the people who are in that neighborhood. So just, no, don't need this, don't need that, don't need this. Then why am I sitting here reading it?
Thank you, Commissioner. Any other questions from staff? All right. I think we're to that moment. Is there a motion?
Motion to close, comments?
I'm sorry. Thank you. Sure do appreciate it. Thank you, Commissioner Columbus, for your motion to close hearing at 8:20. Is there a second?
Second.
Thank you, Commissioner Thompson. All those voting in favor, please say aye. Aye. Any opposed? All right, hearing none, motion passed. Hearing stands closed at 8:20. Is there a motion to approve or this application?
I have a question.
Yes, ma'am.
Based on the applicants, what the applicant said about the SUP and 2CC, is it the commissioner's purview to amend straight out?
Yes, I mean, we can make a motion here, at the dais that reflects, I think, what we've heard and that kind of thing. If there is no motion from our colleagues, I do have clear consideration, but I will offer an opportunity for you all, if somebody else wanted to make a motion.
I have a motion that we approve the base zone as LOR, that we strike the use of lodge and civic club, section 2C, I believe. And we remove section 2CC.
So Commissioner Columbus is, let me just make sure I read it back, is to approve, the application with the following, modifications for call. Strike lodge and civic club use. Allow for, of course, LOR, I won't tamper with the language that's in the document. So only thing you're saying is strike lodge and civic, identify that as a non-permitted use. Anything else on the uses? Would you, I'm gonna do this in real time, would you be amenable to a friendly amendment to require childcare facilities / daycare to be allowed by SUP? Okay, so your motion now include striking lodge and civic use
Yes.
and only permitting childcare by SUP. And then you recommend that the entirety of section CC be stricken.
Yes.
Okay. Would you be amenable to one more friendly amendment? If not, I'm saying, I'll be back with the same motion. My last friendly amendment, colleague, is would you be amenable to changing in the proposed exhibit C, where we currently in subsection 2 have a 3-story max of 40, that match subsection A3, which has a max of 30%.
Yes, I forgot that.
Would you be amenable to that? So my colleague's motion with friendly amendments consists of approving this application with the following modifications: striking civic and lodge uses, allowing childcare by SUP, striking the entirety of that CC section, and amending the site plan to cap maximum height at 30 feet to match that of subsection A. Is there a second? Section, is there any comments?
Yes, I have.
Okay, go ahead.
My comment is that when finding lodging, the definition is,
What we struck was lodge or civic club, which is like lodge and
okay, so you struck that. Okay, that's fine.
Okay.
I just wanted to get a standard of striking.
Yes, ma'am. Yeah, that's what we are.
Okay.
All right, so that's the motion on the floor. I've queued Commissioner O'Brien's question. I'm looking for a second. Commissioner Wynn has seconded. We're now down to comments. I have one. Thank you, colleague, for your forbearance and allowing us me to go through the questions. I've been with this project since its inception. As with any project, there's nothing ever perfect. However, we've been working on it and trying to get it to that place that's perfect. I won't get into who will be where, no mission, and any of that. That I say that for map for people to move. But what I will say is that this, I think, puts this application in a better position to move to council. We just simply are recommenders to that body. Residents and citizens can still go forward with their concerns, but I think based on what we heard today, I'm in full support of Commissioner Columbus's motion with those amendments, and I think that it will shore this up. And to Commissioner O'Brien, to your point, kind of cut out any confusion that may exist and make the ordinance read more straightforward and much more clear, so all are aware of what we have and what we're working with. And I think the neighbors will eventually come to appreciate the reduction in height that's nearest those already existing residential uses. And so let's take a vote by show of hands. So all those voting in favor, please raise your hand. Okay, it's unanimous. I have Commissioners Columbus, Davis, Wynn, and O'Brien voting in favor. Any opposed? I don't see anybody. All right, motion carries, application approved, proposed amendments. All right, now for my favorite agenda item, tell us about the comp plan, Mr. Moore.
Thank you. Very, very quickly, our comprehensive plan is 5 phases. Phase 1 is a discovery and existing conditions assessment, in which the comprehensive plan just kicks off with a deep dive on existing conditions in the community, seeking to understand demographics, operational conditions, and trends surrounding growth and development. That is projected to take 1 to 2 months, so that's the phase that we're actually coming in. We are discovering existing conditions and moving into phase 2, which will be 3 to 5 months as the visioning and strategy development phase, in which for the planning horizon is determined. The steering committee leverages public input and data to determine the best course for the community over the next 15 to 20 years. That's really where we're aiming for with our 2040 vision. Moving into phase 3, 6 to 8 month mark, in which the implementation and action phase with the consultant team working with the steering committee and the public to develop a set of discrete initiatives and action steps necessary to advance the vision. And then being closer to that year mark is where we have a plan in that phase 4, where all of the plan elements and public engagement data is compiled to create the full comprehensive plan, and then adoption in phase 5, in which the steering committee communicates the plan, recommendations to council. There's evaluation from city council, finalization of those elements, and then there's engagement and any other state required reviews and adoption of that plan. Chairman Davis is a member of the steering committee, something that I'm very joyous to disclose, as is our vice chair, Commissioner Reyes. If there's anything additional you'd like to disclose or promote, perhaps the opportunity to get involved as a community, and that's something that I think would be beneficial at this time.
Yeah, thank you for the opportunity, Mr. Moore, and colleagues. Thank you all for the opportunity to serve in this capacity. We're off to a good start. We've gone through the procurement process. I think we have a pretty good firm on board that has the experience, I think, to deliver us a comprehensive plan. You know, so often we've sat around this dais, and I have also on the eco-dev side talked about how do we align what we do with what our future is. And so I think we have a lot of lessons learned since the last time we've done this. And so really looking forward to it. I really want to make sure that you all have a voice and as we continue to do input and make sure the planning and zoning group is in there, and that we're reaching out to the community and making sure that we can hear from them as a body too. You can post a public meeting and figure out how to do that so we can incorporate it into there, because a plan works well when it lines up with vision that residents and neighbors share, the vision of our eco needs, and also sustainable development and being the steward of our zoning opportunities. So I think for me, it's about trying to get all 3 of those lined up and have much input, because this will cast our vision for the foreseeable future. And who knows, we could get down to the end of 10 years and not have very much money. to go out to market for another comprehensive study, and so we have to continue to roll. So I think about it for the next 15 years, it's like, what do we want to see, what do we want to be working on, and making sure we keep that spirit. So we're looking forward to that as we move forward, and so the day has finally, that we're off and running, so I'm happy to know that, so thank you. All right?
Yes, sir, thank you very
Well,
much.
with that, let me not forget my favorite part, is there a motion to adjourn? Thank you, Columbus, do I hear a second?
I second.
Thank you, Mr. O'Brien, all those in favor, say aye. Any opposed? I don't think so, May 30, we stand adjourned, thank you all.
Thank you.
So insufficient.